Members, we now come to the Weathertight Homes Resolution Services Amendment Bill. When we were last debating this bill, the question was that Part 2 stand part. Phil Twyford had the call and he has 3 minutes 54 seconds remaining. So the question is that Part 2 debate on clauses 6 and 7 stand part. Phil Twyford.
Thank you, Mr. Chairman. It's good to recommence this debate on the Weathertight Homes Resolution Services Amendment Bill, and for the people at home who've been following the progress of this bill very closely through the House, they'll be much relieved that debate has recommenced. And they'll remember that Labor is supporting this bill because we want to see this final bit of fine-tuning of the Weathertight Homes Resolution Service, the funding assistance package. We want to see the benefits of that, the fine-tuning contained in this bill, actually realised in the few months that remain before this bill expires. Before we were so rudely interrupted by the passage of time, we were debating Part 2 of this bill, and I want to direct the House's attention to an element in Part 2 that deals with the widening of the definition of the qualifying claimant in Section 125B of the Act. This provision is one of three important elements in the bill, and this one particularly updates the Act in accordance with the court ruling, the Supreme Court ruling in Osborne's versus Auckland Council. And people who've been following this issue will know that John and Helen Osborne took their case, that they'd been denied access to the funding assistance package on a technicality, and they took their case through the system all the way to the Supreme Court, and arguing that the 10-year limitation on leaky building claims should start from when the building is issued with a code of compliance by the council, not when the building itself is physically completed. And because the terminology in the Act refers to the 10-year period kicking in from when the house is built, that sort of vagueness, which subsequently tripped up a lot of people, courts initially ruled that the Osbornes were not eligible for the assistance, the funding assistance under the Act. And good for the Osbornes. They took that fight on. They won at the Supreme Court. Supreme Court agreed with them that the 10-year limitation period the clock should start ticking from the moment that the code of compliance was issued. And as a result of that, I think the government estimates that perhaps 300 families could benefit. So I want to just talk through one particular element that it's not a major issue, but concern was raised by some submitters that the bill actually would have the unintended consequence of making it very difficult for some applicants who had gone ahead and made the repairs on their home, having been turned down for eligibility for the funding assistance package. The concern was that those people would not then be eligible once the bill was passed, allowing for the Osborne principle to be enacted. These people, having gone ahead and enacted and done the repairs, Mr. Chairman, would no longer be eligible. So let me just talk through some of that detail. So the bill deems that owners who were regarded as ineligible based on the case law prior to the Osborne case to be eligible. It basically just deems them eligible based on the Osborne principle. And that's basically about correcting an injustice through arising from an incorrect application of the law. The problem is that if owners had gone ahead and made their repairs to the house, they still wouldn't be able to obtain financial assistance under these provisions because they still would be not able to meet the contribution criteria, which is one of the two key elements they have to meet. And what Section 125C does is that it allows owners who are qualifying claimants to apply to obtain financial assistance. They've got to have an eligible claim, they've got to meet certain contribution criteria set out in the Gazette notice. Now, the Section 166, subsection 5, still requires those owners who have made the repairs, gone ahead, having been deemed ineligible, gone ahead and made the repairs, it still requires them to meet the status of qualifying claimant in all other respects, but that's not possible in the case of people who have gone ahead and repaired their homes. Now, that was raised by submitters, including the Law Society of New Zealand, who feared this was an unintended consequence, and there was no good reason to deny these people access to the assistance scheme. And the government has estimated that there would be about an extra 70 families in that position. And as Paul Grimshaw of Grimshaw and Partners said at Select Committee, this would essentially require a number of these people to undertake lengthy and possibly expensive adjudication to get their result. So what I would ask, Mr. Chairman, is to ask the Minister, who is the Minister responsible for this bill, and that's good for this debate, if he could get up and explain to us whether in fact the changes that the Select Committee made to the bill, I wasn't on the Select Committee, but I suspect that the change that was made in Part 2, Section 166, subsection 4, was designed to remedy that unintended consequence. It's not clear to me from the reading that it is, but I would invite the Minister to get up and explain whether or not those concerns have been met in this case.
I call Sir William Seal.
Chairman, I think it's fair to say that there